Oh, wow. Okay, great. All right. Hello, everyone. Good morning, good afternoon, good evening, wherever it is, whatever it is your time. I am Leonard French, your favorite copyright attorney, and I thought this morning we'd go over the Paul Manafort and Richard Gates indictment, which was, I woke up to it this morning. I had kind of an odd business meeting at about 3 a.m. Tell me if anybody recognizes these people. They were passing through on their way to another destination, and it happened to be 2 to 3 a.m. that we were able to meet, so we just had a very nice diner breakfast together. And they're very, very nice people. So if I seem a little bit groggy, it's because that's what I was doing at 3 a.m. this morning. All right. Also, I haven't had my morning coffee, so here's my morning root beer. Oh, I do apologize for that. So, the Paul Manafort indictment. Thought we would go over this together this morning in sort of a non-political way and try to talk about what it might mean. I have no idea what will happen next. This is quite a an investigation that's going on here. I have no delusions that I understand every little thing that's going on. But let's just jump into this and get this started. Thank you, Svining Torresdal, for your donation. I'm going to take breaks in between sections of the indictment to recognize anyone who's donated, but I'm not going to stop in between. So please do not be offended if I don't call out your donation immediately. But Svining Torresdal, by the way, has already started the Scandinavian bidding war. So this is a filing in the United States District Court for the District of Columbia, the United States of America, versus Paul J. Manafort Jr. and Richard W. Gates III. It is a criminal indictment. The grand jury for the District of Columbia charges the following. At all times relevant to this indictment, defendants Paul Manafort and Richard Gates served for years as political consultants and lobbyists. Between at least 2006 and 2015, Manafort and Gates acted as unregistered agents of the government of Ukraine, the Party of Regions, a Ukrainian political party whose leader Viktor Yanukovych was president from 2010 to 2014. Yanukovych and the Opposition Bloc, a successor to the Party of Regions that formed in 2014 when Yanukovych was fled to Russia. Manafort and Gates generated tens of millions of dollars in income as a result of their Ukraine work. In order to hide Ukraine payments from United States authorities from approximately 2006 through at least 2016, Manafort and Gates laundered the money through scores of United States and foreign corporations, partnerships, and bank accounts. In furtherance of the scheme, Manafort and Gates funneled millions of dollars in payments into foreign nominee companies and bank accounts opened by them and their accomplices in nominee names and in various foreign countries, including Cyprus, St. Vincent, and the Grenadines. I guess they're referring to St. Vincent and the Grenadines as one thing, and the Seychelles. Somebody correct me on that one. Manafort and Gates hid the existence of the foreign companies and bank accounts, falsely and repeatedly reporting to their tax preparers and the United States that they had no foreign bank accounts. In furtherance of the scheme, Manafort and Gates concealed from the United States their work as agents of and millions of dollars in payments from Ukraine and its political parties and leaders. Because Manafort and Gates, among other things, directed a campaign to lobby United States officials on behalf of the government of Ukraine, the president of Ukraine, and Ukrainian political parties, they were required by law to report to the United States their work and fees. Manafort and Gates did not do so. I will figure out how to pronounce this, whether it's Manafort or Manafort, sorry. Instead, when the Department of Justice sent inquiries to Manafort and Gates in 2016 about their activities, Manafort and Gates responded with a series of false and misleading statements. In furtherance of the scheme, Manafort used his hidden overseas wealth to enjoy a lavish lifestyle in the United States without paying taxes on that income. Manafort, without reporting the income to his tax preparer or the United States, spent millions of dollars on luxury goods and services for himself and his extended family through payments wired from offshore nominee accounts to United States vendors. Manafort also used these offshore accounts to purchase multi-million-dollar properties in the United States. Manafort then borrowed millions of dollars in loans using these properties as collateral, thereby obtaining cash in the United States without reporting and paying taxes on the income. In order to increase the amount of money he could access in the United States, Manafort... It's Manafort, not Manafort. Thank you, Mary. In order to increase the amount of money he could access in the United States, Manafort defrauded the institutions that loaned money on these properties so that they would lend him more money at more favorable rates than he would otherwise be able to obtain. Gates aided Manafort in obtaining money from these offshore accounts, which he was instrumental in opening. Like Manafort, Gates used money from these offshore accounts to pay for his personal expenses, including his mortgage, children's tuition, and interior decoration of his Virginia residence. In total, more than $75 million flowed through the offshore accounts. Manafort laundered more than $18 million, which was used by him to buy property, goods, and services in the United States, income that he concealed from the United States Treasury, the Department of Justice, and others. Gates transferred more than $3 million from the offshore accounts to other accounts that he controlled. Manafort is a citizen. He resides in Virginia, Florida, and Long Island. Gates is a citizen. He resides in Virginia. In 2005, Manafort and another partner created Davis Manafort Partners, Inc., DMP, to engage principally in political consulting. DMP had staff in the U.S., Ukraine, and Russia. In 2011, Manafort created DMP International, DMI, to engage in work for foreign clients, in particular political consulting, lobbying, and public relations for the government of Ukraine, the Party of Regions, and members of the Party of Regions. DMI was a partnership solely owned by Manafort and his spouse. Gates worked for both DMP and DMI and served as Manafort's right-hand man. The Party of Regions was a pro-Russia political party in Ukraine. Beginning in approximately 2006, it retained Manafort through DMP and then DMI to advance its interests in Ukraine, including the election of its slate of candidates. In 2010, its candidate for president, Yanukovych, was elected president of Ukraine. In 2014, Yanukovych was fled Ukraine for Russia in the wake of popular protests of widespread governmental corruption. Yanukovych, the Party of Regions, and the government of Ukraine were Manafort, DMP, and DMI clients. The European Center for a Modern Ukraine, the Center, was created in or about 2012 in Belgium as a mouthpiece for Yanukovych and the Party of Regions. The center was used by Manafort, Gates, and others in order to lobby and conduct a public relations campaign in the U.S. and Europe on behalf of the existing Ukraine regime. The center effectively ceased to operate upon the downfall of Yanukovych in 2014. Manafort and Gates owned or controlled the following entities which were used in the scheme. These are the Manafort-Gates entities. Domestic entities included Bade LLC in Delaware, Daisy Manafort in Virginia and Florida, Davis Manafort International in Delaware, DMP in Virginia and Florida, Davis Manafort Inc. in Delaware and Virginia, DMI, I'm going to stop saying the locations, Global Sites LLC, Jamina, Jason Investments, John Hanna, Jupiter Holdings, Lil Red, Loave, LOAV Limited, MC Brooklyn Holdings, Smithin LLC, also known as Smithson Synthson LLC, so Smithson and Synthson, Actinet Trading Limited, Black Sea Limited, Bletia Ventures, Cavanari Investments, Global Highway Limited. These are all in Cyprus now. These are the Cyprus entities. Marziola, Olivenia, Paranova, Saragon, Global Endeavor, Jeanette, and Pompolo Limited. The IRS was a bureau in the U.S. Department of Treasury responsible for administering the tax laws. In or around 2008 and 2017, both dates being approximate and inclusive, in D.C. and elsewhere, Manafort and Gates devised and intended to devise and executed and attempted to execute a scheme and artifice to defraud, to obtain money and property by means of false and fraudulent pretenses and promises from the United States, banks, and other financial institutions. As part of this scheme, Manafort and Gates repeatedly provided false information to financial bookkeepers, tax accountants, and legal counsel, among others. Manafort and Gates' wiring of money from offshore accounts into the U.S. in order to use the money in the offshore nominee accounts of the Manafort-Gates entities without paying taxes on it, Manafort and Gates caused millions of dollars in wire transfers from these accounts to be made for goods, services, and real estate. They did not report these transfers as income to DMP, DMI, or Manafort. From 2008 to 2014, Manafort caused the following wires totaling over $12 million to be sent to the vendors listed below for personal items. Manafort did not pay taxes on this income, which was used to make the purchases. Vendor A was for a home improvement company in the Hamptons, New York. And here's a list of hundreds of thousands of dollars. A total of $5 million. Vendor B was a home automation, lighting, and home entertainment company in Florida. Oh, I used to work in that industry. I think I know who that is. I'll leave their name out of it. Vendor C is an antique rug store in Alexandria, Virginia, about $1 million. Vendor D was related to the antique rug store, $100,000 to Cyprus. A men's clothing store in New York received $849,000. Could you imagine buying $849,000 worth of clothing? A landscaper in the Hamptons, New York, was paid $655,000. An antique dealer in New York was paid $624,000. A clothing store in Beverly Hills was paid $520,000. I don't know if I've made $520,000 in my lifetime, and he spends it on clothing using illegal money. An investment company in the Grenadines got $500,000. A contractor in Florida got $432,000. A landscaper in the Hamptons got $164,000. Let's see. We'll start skipping. 3 Range Rovers. A contractor in Virginia. Audio-video control system, home integration and installation. Purchase of a Mercedes-Benz, purchase of a Range Rover, property management company in South Carolina, an art gallery in Florida, and housekeeping, $20,000 worth of housekeeping in New York. In 2012, Manafort caused the following wires to be sent to the entities listed below to purchase the real estate listed below. Manafort did not report the money used to make these purchases on his 2012 tax return. A Howard Street condominium, a Union Street brownstone, and an Arlington house, each valued at about $1.2 to $1.9 million. Manafort and Gates' hiding of Ukraine lobbying and public relations work. It is illegal to act as an agent of a foreign principal engaged in certain U.S. influence activities without registering the affiliation. Specifically, a person who engages in lobbying or public relations work in the U.S., hereafter collectively referred to as lobbying, for a foreign principal such as the government of Ukraine or the Party of Regions is required to provide a detailed written registration statement to the U.S. Department of Justice. The filing made under oath must disclose the name of the foreign principal, the financial payments to the lobbyist, and the measures undertaken for the foreign principal, among other information. A person required to make such a filing must further make in all lobbying material a conspicuous statement, a visible, easily seen statement that the materials are distributed on behalf of the foreign principal, among other things. Thus, the filing thus permits public awareness and evaluation of the activities of a lobbyist who acts as an agent of a foreign power or foreign political party in the United States. In furtherance of the scheme, from 2006 until 2014, both dates being approximate and inclusive, Manafort and Gates engaged in a multi-million-dollar lobbying campaign in the U.S. at the direction of Yanukovych, the Party of Regions, and the government of Ukraine. Manafort and Gates did so without registering and providing the disclosures required by law. As part of the scheme, in February 2012, Manafort and Gates solicited two Washington, D.C. firms, A and B, to lobby in the United States on behalf of Yanukovych, the Party of Regions, and the government of Ukraine. For instance, Gates wrote to Company A that it would be representing the government of Ukraine in Washington, D.C. Manafort repeatedly communicated in person and in writing with Yanukovych, and Gates passed on directions to Company A and Company B. For instance, Manafort wrote Yanukovych a memorandum dated April 8, 2012, in which he provided Yanukovych an update on the lobbying firm's activities since the inception of the project a few weeks ago. Quote, "It is my intention to provide you with a weekly update moving forward." Toward the end of the year, in November 2012, Gates wrote to Company A and Company B that the firms needed to prepare an assessment of their past and prospective lobbying efforts so the president could be briefed by Paul on what Ukraine has done well and what it can do better as we move into 2013. I'm going to read that sentence again. Toward the end of that first year, in November of 2012, Gates wrote to Company A and B that the firms needed to prepare an assessment of their past and prospective lobbying efforts so the president could be briefed by Paul on what Ukraine has done well and what it can do better as we move into 2013. I'm really curious which president is being referred to in 2012. At the direction of Manafort and Gates, Company A and Company B engaged in extensive lobbying. Among other things, they lobbied multiple members of Congress and their staffs about Ukraine sanctions, the validity of Ukraine elections, and the propriety of Yanukovych's imprisoning his presidential rival, Yulia Tymoshenko, who had served as Ukraine president prior to Yanukovych. Manafort and Gates also lobbied in connection with the rollout of a report concerning the Tymoshenko trial commissioned by the government of Ukraine. Manafort and Gates used one of their offshore accounts to funnel $4 million to pay secretly for the report. To minimize public disclosure of their lobbying campaign, Manafort and Gates arranged for the center to be the nominal client of Company A and Company B, even though, in fact, the center was under the ultimate direction of the government of Ukraine, Yanukovych, and the Party of Regions. For instance, Manafort and Gates selected Company A and B, and only thereafter did the center sign contracts with the lobbying firms without ever meeting either company. Company A and Company B were paid for their services not by their nominal client, the center, but solely through offshore accounts associated with the Manafort-Gates entities, namely Blatia Ventures Limited in Cyprus and Jeannet Limited and Global Endeavor Inc. in Grenadines. In total, Company A and B were paid more than $2 million from these accounts between 2012 and 2014. To conceal the scheme, Manafort and Gates developed a false and misleading cover story that would distance themselves and the government of Ukraine, Yanukovych, and the Party of Regions from the center, Company A and Company B. For instance, in the wake of extensive press reports on Manafort and his connections with Ukraine, on August 16, 2016, Gates communicated false talking points to Company A in writing, including, question, can you describe your initial contact with Company B and the lobbyist goals he discussed with them? Answer, we provided an introduction between the Center and Company B and A in 2012. The Center was seeking to retain representation in Washington, D.C. to support the mission of the NGO. NGO usually means non-governmental organization. Our Manafort and Gates task was to assist the Center find representation in Washington, but at no time did our firm or members provide any direct lobbying support. Answer, the structure of the arrangement between the Center and Company A and B was worked out by the two parties. Question, can you say where the funding for the Center came from? This amounted to well over $1 million between 2012 and 2014. Answer, this is a question better asked of the Center, who contracted with the two firms. Question, can you describe the lobbying work specifically undertaken by Company B on behalf of the Party of Regions and the Center? Answer, this is a question better asked to Company B and or the Center, as the agreement was between the parties. Our firm did not play a role in the structure, nor were we registered lobbyists. Company B, through a principal, replied to Gates that same day that there's a lot of email traffic that has you much more involved than this suggests. We will not disclose that, but heaven knows what former employees of Company A or B might say. In September 2016, after numerous recent press reports concerning Manafort, the Department of Justice informed Manafort, Gates, and DMI that it sought to determine whether they had acted as agents of foreign principal under the Foreign Agents Registration Act without registering. In November 2016 and February 2017, Manafort, Gates, and DMI caused false and misleading letters to be submitted to the Department of Justice, which mirrored the false cover story set out above. The letters, both of which were approved by Manafort and Gates before they were submitted, represented, among other things, that DMI's efforts on behalf of the Party of Regions did not include meetings or outreach within the U.S., that Manafort and Gates did not recall meeting with or conducting outreach to U.S. government officials or U.S. media outlets on behalf of the Center, nor do they recall being party to, arranging, or facilitating any such communications. Rather, it is the recollection and understanding of Messrs. Gates and Manafort that such communication would have been facilitated and conducted by the Center's U.S. consultants as directed by the Center. Manafort and Gates had merely served as a means of introduction of Company A and B to the Center and provided the Center with a list of potential U.S.-based consultants, including Company A and B, for the Center's reference and further consideration. DMI does not retain communications beyond 30 days, and as a result of this policy, a search has returned no responsive documents, to a subpoena, I'm assuming. The November 2016 letter attached a one-page, undated document that purported to be a DMI email retention policy. In fact, Manafort and Gates had selected Company A and Company B, engaged in weekly scheduled calls and frequent emails with Company A and Company B, to provide them directions as to specific lobbying steps that should be taken, sought, and received detailed oral and written reports from these firms on the lobbying work they had performed, communicated with Yanukovych to brief him on their lobbying efforts, both congratulated and reprimanded Company A and B on their lobbying work, communicated directly with U.S. officials in connection with this work, and paid the lobbying firms over $2 million from offshore accounts they controlled, among other things. In addition, court-authorized searches of Manafort and Gates' DMI email accounts and Manafort's Virginia residence in July 2017 revealed numerous documents, including documents related to lobbying, which were more than 30 days old at the time of the November 2016 letter to the DOJ. Manafort and Gates' hiding of foreign bank accounts and false filings. U.S. citizens who have authority over certain foreign bank accounts, whether or not the accounts are set up in the names of nominees who act for their principals, have reporting obligations to the United States. First, the Bank Secrecy Act and its implementing regulations require U.S. citizens to report to the U.S. Treasury any financial interest in or signatory authority over any bank account or other financial account held in foreign countries for every calendar year in which the aggregate balance of all such foreign accounts exceeds $10,000 at any point during the year. This is commonly known as a Foreign Bank Account Report, or an FBAR. The Bank Secrecy Act requires these reports because they have a high degree of usefulness in criminal, tax, or regulatory investigations or proceedings. The U.S. Treasury's Financial Crimes Enforcement Network, FinCEN, is the custodian for FBAR filings, and FinCEN provides access to its FBAR database to law enforcement entities, including the Federal Bureau of Investigation. The reports filed by individuals and businesses are used by law enforcement to identify, detect, and deter money laundering that furthers criminal conspiracy, enterprise activity, tax evasion, and other unlawful activities. Second, United States citizens are also obligated to report information to the IRS regarding foreign bank accounts. For instance, in 2010 Form 1040, Schedule B had a yes or no box to record an answer to the question, at any time during the calendar year, did you have an interest in or signature or other authority over a financial account in a foreign country, such as a bank account, securities account, or other financial account? If the answer was yes, then the form required the taxpayer to enter the name of the foreign country in which the financial account was located. For each year in or about and between 2008 and at least 2014, Manafort had authority over foreign accounts that required an FBAR report. Specifically, Manafort was required to report to the U.S. Treasury each foreign bank account held by the foreign Manafort Gates entities noted in paragraph 12 above that bear the initials PM. No FBAR reports were made by Manafort for these accounts. For each year in or about and between 2008 and at least 2013, Gates had authority over foreign accounts that required an FBAR account. Specifically, Gates was required to report to the U.S. Treasury each foreign bank account held by the foreign entity noted in paragraph 12, etc. No FBAR reports were made by Gates for these accounts. Furthermore, in each of Manafort's tax filings for 2008 through 2014, Manafort represented falsely that he did not have authority over any foreign bank accounts. Manafort and Gates had repeatedly and falsely represented in writing to Manafort's tax preparer that Manafort had no authority over foreign bank accounts, knowing that such false representations would result in false Manafort tax filings. For instance, on October 4, 2011, Manafort's tax preparer asked Manafort in writing, "At any time during 2010, did you or your wife or children have an interest in or signature or other authority over a financial account in a foreign country, such as a bank account, securities account, or other financial account?" On that same day, Manafort falsely responded, "No." Manafort responded the same way as recently as October 3, 2016, when Manafort's tax preparer again emailed the question in connection with the preparation of Manafort's tax returns. "Foreign bank accounts, etc.? None," responded Manafort. Manafort and Gates' fraud to increase access to offshore money. After Manafort used his offshore accounts to purchase real estate in the U.S., he took out mortgages on the properties, thereby allowing Manafort to have the benefits of liquid income without paying taxes on it. Further, Manafort defrauded the banks that loaned him the money so that he could withdraw the money at a cheaper rate than he otherwise would have been permitted. In 2012, Manafort, through a corporate vehicle called MC Soho Holdings, owned by him and his family, bought a condominium on Howard Street in the Soho neighborhood in Manhattan, New York. He paid approximately $2.8 million. All the money used to purchase the condominium came from the Manafort entities in Cyprus. Manafort used the property from at least January 2015 through 2016 as an income-generating rental property, charging thousands of dollars a week on Airbnb, among other places. In his tax returns, Manafort took advantage of the beneficial tax consequences of owning this rental property. In late 2015, And early 2016, Manafort applied for a mortgage on the condominium because the bank would permit a greater loan amount if the property were owner-occupied. Manafort falsely represented to the bank and its agents that it was a secondary home used as such by his daughter and son-in-law and was not a property held as a rental property. For instance, January 26, 2016, Manafort wrote to his son-in-law to advise him that when the bank appraiser came to assess the condominium, his son-in-law should remember he believes that you and Manafort's daughter are living there. Based on a request from Manafort, Gates caused a document to be created which listed the Howard Street property as the second home of Manafort's daughter and son-in-law, when Gates knew this fact to be false. As a result of his false representations, in March 2016, the bank provided Manafort a loan for approximately $3.2 million. Also, in 2012, Manafort, through a corporate vehicle called MC Brooklyn Holdings LLC, similarly owned by him and his family, bought a brownstone on Union Street in the Carroll Gardens section of Brooklyn, New York. He paid approximately $3 million in cash for the property. All of that money came from a Manafort entity in Cyprus. After purchase of the property, Manafort began renovations to transform it from a multi-family dwelling into a single-family home. In late 2015 and early 2016, Manafort sought to borrow cash against the property. The institution Manafort went to for the loan provided greater loan amounts for construction loans. That is, loans that required the loan amounts to be used to pay solely for construction of the property and thus increase the value of the property, serving as the loan's collateral. The institution would thus loan money against the expected completed value of the property, which in the case of the Union Street property was estimated to be $8 million. In early 2016, Manafort was able to obtain a loan of approximately $5 million after promising the bank that $1.4 million of the loan would be used solely for construction of the property. However, Manafort never intended to limit the use of the proceeds to construction as required by the loan contracts. In 2015, before the loan was made, Manafort wrote to his tax preparer, among others, that the construction loan will allow me to pay back the other Manafort apartment mortgage in full. Further, when the construction loan closed, Manafort used hundreds of thousands of dollars from the construction loan to make a down payment on another property in California. Statutory allegations. Count 1. Conspiracy against the United States. From in or about 2006-2017, both dates approximate and inclusive, in D.C. and elsewhere, Manafort and Gates, together with others, knowingly and intentionally conspired to defraud the U.S. by impeding, impairing, obstructing, defeating the lawful governmental functions of a governmental agency, namely the DOJ and the Department of the Treasury, and to commit offenses against the United States, to wit, the violations of law charged in counts 3 through 6 and 10 through 12. In furtherance of the conspiracy and to effect its illegal object, Manafort and Gates committed the overt acts noted in Count 11 and the overt acts, among others, in D.C. and elsewhere in the listed paragraphs. Count 2. Conspiracy to launder money. In or around 2006 to 2016, within D.C. and elsewhere, Manafort and Gates, together with others, did knowingly and intentionally conspire to a. Transport, transmit, transfer money, instruments, and funds from places outside the U.S. to and through places in the U.S., and from places in the U.S. to and through places outside the U.S., with the intent to promote the carrying on of specified unlawful activity, to wit, a felony violation of the FARA in violation of Title 22, and Title 18. B. Conduct financial transactions affecting interstate and foreign commerce, knowing that the property involved in the transactions would represent the proceeds of some form of unlawful activity, and the transactions in fact would involve the proceeds of specified unlawful activity, knowing that such financial transactions were designed in whole or in part to 1. Engage in conduct constituting a violation of Sections 7201 and 7206 of the Internal Revenue Code of '86, and 2, conceal and disguise the nature, location, source, ownership, and control of the proceeds of the specified unlawful activity in violation of Title 18 of the U.S. Code. Counts 3 through 6, on the filing due dates listed below in the District of Columbia and elsewhere, Manafort unlawfully, willfully, and knowingly failed to file with the Department of Treasury an FBAR report disclosing that he has a financial interest in and signature and other authority over a bank, securities, or other financial account in a foreign country which had an aggregate value of more than $10,000, while violating another law of the U.S. as part of a pattern of illegal activity involving more than $100,000 in a 12-month period during the years listed below, 2011, 12, 13, and 14. Counts 7 through 9. Failure to file reports of foreign bank account and financial accounts for 2011 to 13. On the filing due dates listed below in the District of Columbia and elsewhere, Defendant Gates unlawfully, willfully, and knowingly did fail to file FBAR reports with the $10,000 thing and violating the $100,000 and 12-month thing, 2011 to 2013 for Mr. Gates. Count 10, unregistered agent of a foreign principal from in or about 2008 to 2014, both dates being approximate and inclusive. Manafort and Gates knowingly and willfully, without registering with the Attorney General as required by law, acted as agents of a foreign principal, the government of Ukraine, the Party of Regions, and Yanukovych. Count 11, false and misleading FARA statements. On or about November 23, 2016 and February 10, 2017, in D.C. and elsewhere, Manafort and Gates knowingly and willfully caused to be made a false statement of material fact or omitted a material fact necessary to make the statements not misleading in a document filed with and furnished to the Attorney General under the provisions of FARA, to wit, the underlined statements. DMI's efforts on behalf of the Party of Regions did not include meetings and outreach within the U.S. Neither DMI nor Mr. Manafort or Gates had any agreement with the Center to provide services. DMI did provide the Center with a list of potential U.S.-based consultants for the Center's reference and further consideration. The Center then contracted directly with Company A and B to provide services with the United States. To Gates' recollection, these efforts included providing policy briefings to the Center and its consultants on key initiatives and political developments in Ukraine, including participation in and coordination of related conference calls and meetings. Although Gates recalls interacting with the Center's consultants regarding efforts in the Ukraine and Europe, neither Gates nor Mr. Manafort recall meeting with or conducting outreach to U.S. government officials or U.S. media outlets on behalf of the Center, nor do they recall being party to arranging or facilitating any such communications. Rather, it is the recollection and understanding of Mr. Gates and Manafort that such communications would have been facilitated and conducted by the Center's U.S. consultants as directed by the Center, pursuant to the agreement reached by those parties to which DMI was not a party. And a search has been conducted for correspondence containing additional information related to the matters described in the government's letters. However, as a result of DMI's email retention policy, which does not retain communications beyond 30 days, the search has returned no responsive communications. Count 12, false statements. On or about November 23, 2016 and February 10, 2017, within D.C. and elsewhere, Defendants Manafort and Gates knowingly and willfully did cause another to falsify, conceal, and cover up by a scheme and device a material fact to make a materially false, fictitious, and fraudulent statement and representation, and to make use a false writing or document knowing that the same contained a materially false, fictitious, or fraudulent statement. To wit, the statements in the November 23rd, 2016 and February 10th, 2017 submissions to the Department of Justice quoted in paragraph 49 above. Forfeiture allegation. We get a bonus. Pursuant to Federal Rule of Criminal Procedure 32.2, notice is hereby given to the defendants that the United States will seek forfeiture as part of any sentence in accordance with Title 18 U.S. Code and Title 28 U.S. Code, in the event of the defendant's conviction under Count 2 of this indictment. Upon conviction of the offense charged in Count 2, the defendants Manafort and Gates shall forfeit to the U.S. any property, real or personal, involved in such offense, and any property traceable to such property. Wow. Upon conviction of the offenses charged in Counts 10 and 11, the defendants Manafort and Gates shall forfeit to the United States any property which constitutes or is derived from the proceeds traceable to the offense. Notice is further given that upon conviction, the U.S. intends to seek a judgment against each defendant for a sum of money representing the property described in this paragraph as applicable to each defendant. The grand jury finds probable cause to believe that the property subject to forfeiture by Manafort includes, but is not limited to, the real property and premises at 377 Union Street, Brooklyn, New York, including all appurtenances, improvements, and attachments. The real property located at 29 Howard Street, number 4D, New York, New York. The real property and premises commonly known as 1046 North Edgewood Street, Arlington, Virginia. The real property at 174 Jobs Lane, Watermill, New York. And Northwestern Mutual Universal Life Insurance Policy at this number. In case you're unaware, a universal life insurance policy usually carries a savings account with it. So as you're paying your insurance, you're also paying into a savings account. So that's an easy way to hide some money, I guess, or try to hide some money. I'm not recommending it. These things are above board, and I'm sure the insurance company is cooperating with the investigation. Substitute assets. If any of the property described above as being subject to forfeiture as a result of any act or omission of defendant cannot be located, transferred, placed in jurisdiction substantially, or has been substantially diminished in value or has been commingled, it is the intent of the United States, pursuant to Title 18 and Title 28, to seek forfeiture of any other property of said defendant. Signed, Robert S. Mueller III, Special Counsel for the Department of Justice. No, that's not what I wanted to do. But that'll work. We can go back here. Holy mackerel. I don't even know where to begin. That's a lot of illegal stuff, if that's true. I'm going to guess that Robert Mueller, special investigator, wouldn't have brought these charges to the grand jury, and that the grand jury wouldn't have indicted if there wasn't some merit to this. So this is, wow, I don't even know what to say. So the dates we were talking about, I guess, let's look at the important dates. The important dates that we're talking about seem to be up to 2016. So this is from like 2004, 6, 8, all the way up to now is when this has been going on. We only have information about the Gates and Manafort indictments here. We don't have any more information. I am curious, the one section referred to a president. I don't know if that was president of the U.S. or president of a company or something. President of the Ukraine, that could be it. Maybe that's what they were referring to, the president of the Ukraine, Yanukovych. That may have made more sense, rather than referring to Trump or Obama, or because that would make no sense to refer to Trump in 2012. I don't even know that any of us were thinking that in 2012. Maybe he was, and you could convince me, but I'm at this point thinking that was not referring to future President Trump. I hope it doesn't involve President Obama. None of this stuff seemed to be any of Obama's doing. So I think they're probably referring to the president of Ukraine, Yanukovych. Wow. Holy mackerel. I don't even know how to begin with this. So that's just very, that's a lot. I want to use the word entertaining. I hate to use the word so lightly. this is my country that this is happening in, and I could not even begin to tell you what connection this will have to, everything that's going on in our political spectrum these days. But we're going to find out. Maybe this is the beginning and the end of it, or maybe this is just the beginning of it. I don't know. We have no reason to know or speculate really what he's going to find from here. I did not expect this level. So who knows? Maybe when they announced the indictment on Friday, it would just be like some small fish or something like that. No, it's Paul Manafort, political consultant and lobbyist, and Richard Gates. I honestly don't remember who Richard Gates is, besides what they told us here. But that's whew, that's a lot. I have no idea what the pardon powers limits are and whether someone could be pardoned for this. If it's solely federal charges, I think so, but I am not entirely sure what the pardon powers limits are there. The process will take as long as it takes. I'm really not sure. The investigation's been going on for some time now. Robert Mueller has been involved since Comey was fired in April or May. So if it took him only 6 months to put together this indictment at this level of detail, I'd say we will probably have movement or news within the next 6 months, if not sooner. But who really knows? It seems to be a pretty well thought out and well written indictment. So I really don't know. And one of the things that I'm going to caution people against is a lot of speculation and political pandering. This is a real thing. This is a real criminal indictment. This is a real thing that's happening. And I know it can be funny to be politically hyperbolic, lock him up, lock her up, Benghazi, Niger. That's all fine to jump on a bandwagon and get all pumped up, but people recognize what you're doing or recognize what's being done. That's not productive to a furthering of the governance of a people. It's that stuff might be entertaining, but that's the most we should take it for. So that's why I try to focus solely on what we can actually see and read that comes from and through the court system and other reliable sources, and figure out what is actually going on in the world. So that's a heck of a thing. So I see some people asking who Paul Manafort was. Let's do the Wikipedia page like we do sometimes. Nope, not fought. Fort. There we go. So Paul Manafort is a American political consultant, and if I can find a Wikipedia page. American lobbyist, political consultant, and lawyer. He joined Donald Trump's presidential campaign in March 2016 and served as campaign manager from June to August of 2016. He was an advisor to Republicans Gerald Ford, Ronald Reagan, H.W. Bush, and Bob Dole. He co-founded Black, Manafort and Stone, a DC-based lobbying firm. He often lobbied on behalf of controversial foreign leaders such as Yanukovych, Ferdinand Marcos from the Philippines, the Democratic Republic of Congo, Mobutu Sese Seko, and Angolan guerrilla leader Jonas Savimbi. Lobbying to serve the interests of foreign governments requires registration, and it looks like they've already got in here that he hasn't registered. On June 27th, 2017, he retroactively registered as a foreign agent, according to Wikipedia here. So, interesting. Interesting, interesting, interesting. Uh, Thank you very much, chat. I've had my eye on it, and as much as we are talking about something that could very well be politically charged, I am seeing a minimum number of terrible messages. So I appreciate that. Thank you very much for your meaningful participation in this. I'm not sure that I'm going to be taking really any questions about this stream. One, I'm not an expert on these kinds of indictments. I haven't been following, at the level that I would need to be like some kind of commentator on this. And it's a terribly, terribly, terribly politically charged area. So I'm not interested in the politics on stream. So I think we're going to stop it there. So thank you for joining me. Um, this has been an interesting past few days. Just about everything that I've done has been demonetized. We did a show yesterday where I did 7 stories. The show itself was demonetized, and 4 of the stories now have been demonetized, even though we're just doing this talking head educational style discussion video. So I really do appreciate all of your Patreon donations. I don't think I have a link in the description, so if you really want to support and you're not a Patreon supporter, you can find me at patreon.com/ljfrench, I think it is. My Patreon supporters for October are Joshua Meinsiker, John Steele, John Cripps, Nate Beck, Lydia Collinson, and Weston Loney, who are supporting at the $50 plus level. And then I have a large number of other supporters who are both scrolling on the LED panel behind me, will be in the description below of the video, and of course are all listed on Patreon when they want to be, and not when they want to be as well. So thank you to all of those people and all of you for supporting me, for joining me, for learning about this new thing that happened here with the indictment of Paul Manafort and Richard Gates. So I appreciate you all. I am Leonard French, your favorite copyright attorney, and I will see you in my next video. We're going to publish a couple of the videos that were flagged yesterday as soon as they get unflagged, and so there will be a few things from the stream that will post up on the feed. So if you would like to see anything that you missed in the stream yesterday, we also have those things coming, so you don't have to go sit through a 2.5 hour or click through a 2.5 hour stream to figure out what you want to see. So anyway, again, I'm Leonard French, your favorite copyright attorney. Thank you very much for joining me, and I'll see you in my next video.